Anacita, Maine, July 13th, 2026. It is early morning, and according to reports, a 26-year-old man is driving to work. Community members describe him as a Colombian national who, they say, held a valid United States Social Security number and federal work authorization. Reports say that at some point during that drive, he encountered federal immigration officers. Reports say he did not survive the encounter. Federal officials have not named the officer involved, have not released body camera footage, and have confirmed only one thing with certainty: that a mandatory review is now underway. So what, exactly, does that review examine, and what has to be true for it to end in criminal charges? By the end of this, you'll understand precisely what has to happen over roughly the next 90 days for a federal officer to face charges in a fatal shooting like this one, the specific legal threshold, who decides, and the single word in a 1945 Supreme Court ruling that has quietly determined the outcome of nearly every case like it. And you'll understand why, over the last 15 years, in fatal shootings involving ICE and Customs and Border Protection, that outcome has been extraordinarily rare. Not impossible, rare. Keep that word in mind, because we're going to end exactly there. First, what reports actually say. And it's important to separate what is alleged from what is established. According to local reporting and statements attributed to the man's family, he was on his way to a job when he was stopped or approached by federal immigration officers. The family alleges he posed no threat. Witnesses quoted in early coverage claim he was in his vehicle. Federal authorities have released almost none of this. The account circulating publicly is, at this stage, largely the families and the communities. That distinction matters, and it will matter to the review. What is not in dispute is the public response. Community members have organized protests in the days since. Reports describe crowds gathering outside a federal building, holding signs and chanting. Among the chants reported by attendees and local media, "No KKK, no fascist USA, no ICE, out of Maine." Faith leaders and immigrant advocacy organizations have called for the officer's name to be released and for an independent investigation. Federal officials, for their part, have said only that the incident is under review and have declined to comment on specifics, citing that ongoing review. That phrase, under review, sounds passive. It is not. It refers to a defined, multi-stage federal process with statutory deadlines, specific decision-makers, and a legal standard that is written down. That process is public record, and that is where we're going to spend most of our time, because that is what will actually determine what happens next. So here's what the review must examine. When a federal immigration officer, whether ICE or Customs and Border Protection, is involved in a fatal use of force, more than one review opens at once, and they run on parallel tracks. The first track is internal. The agency's own use of force review board examines whether the officer complied with agency policy. For CBP, that's the Use of Force Policy Handbook. For ICE, it's the agency's use of force directives. This internal review asks a narrow question. Did the officer follow the rules the agency set for itself? Critically, that is not the same question as whether a crime occurred. An officer can violate policy without being charged and, at least in theory, could follow policy and still face legal exposure. Policy and criminal law are two different rulers. The second track is oversight. The Department of Homeland Security's Office of Inspector General, DHSOIG, has authority to review deaths involving DHS personnel and, by long-standing practice, is notified of in-custody and use-of-force deaths. DHSOIG can investigate independently or refer the matter. Its findings can become public through published reports, though often long after the fact. The third track, the one everyone is really asking about, is criminal. And for a federal officer, a state prosecutor in Maine has limited reach. Federal officers acting in their official capacity are generally shielded from state prosecution under the Supremacy Clause, through what's known as Supremacy Clause immunity. That pushes the criminal question to the federal government itself, specifically to the Civil Rights Division of the Department of Justice. Here is the statute at the center of it. Title 18, United States Code, Section 242. Deprivation of rights under color of law. It makes it a federal crime for anyone acting under government authority to willfully deprive a person of a right protected by the Constitution or federal law. In a fatal shooting, the relevant right is the Fourth Amendment right to be free from unreasonable seizure, and the Supreme Court has held that deadly force is a seizure. So the framework exists. On paper, an officer who uses unjustified deadly force has deprived someone of a constitutional right under color of law. But read that statute again, because one word does almost all of the work. Willfully. The Department of Justice cannot win a Section 242 case by proving the shooting was a mistake, or negligent, or even that it was an unreasonable use of force under the Fourth Amendment. Prosecutors have to prove the officer acted willfully, that he acted with the specific intent to do something the law forbids. That standard did not come from nowhere. It comes from a 1945 Supreme Court case, Screws v. United States. In Screws, the court confronted a fear that a broadly written civil rights statute could criminalize any official who happened to violate some constitutional rule, even unknowingly. To save the statute, the court read willfully, narrowly. The government must show the defendant acted with a bad purpose to deprive someone of a specific constitutional right, not merely that a right was, in fact, violated. That is the single highest hurdle in this entire process. It is the reason so many of these cases end where they end. A prosecutor can look at a fatal shooting, believe it was tragic, believe it was even unjustified, and still conclude that proving specific, willful criminal intent to a jury beyond a reasonable doubt is not achievable. Historically, this is precisely where similar cases have ended. The Civil Rights Division's review typically works like this. Investigators, often the FBI, gather evidence, the officer's account, witness statements, forensic and autopsy findings, any available video. Career prosecutors assess it against the Screws willfulness standard. If they conclude the evidence cannot meet that bar, they issue a declination, a formal decision not to prosecute, frequently accompanied by a public statement explaining that the government could not establish the required criminal intent. If they believe the standard can be met, the matter can go to a federal grand jury, which decides whether to return an indictment. That decision, to charge or to decline, is the fork in the road. And to understand which way this fork usually bends, you have to look at the cases that built the road. Consider Anastacio Hernandez-Rojas. In May 2010, Hernandez-Rojas, a Mexican national who had lived for years in San Diego, was in CBP custody at the San Isidro port of entry. What happened next was partially captured on bystander cell phone video that later aired publicly, including on network news. The footage showed him on the ground, surrounded by agents, being struck and repeatedly shocked with a taser. He stopped breathing at the scene and died days later. The San Diego County medical examiner ruled the death a homicide and noted a heart attack, methamphetamine in his system, and numerous injuries. His family said he had been beaten. Agents said he had been combative. The federal review took roughly 5 years. In 2015, the Department of Justice announced it was closing the investigation without charges.
The department's statement reflected the familiar conclusion. The evidence was insufficient to prove, beyond a reasonable doubt, that any agent acted willfully to violate Hernandez-Rojas' civil rights under the Screws standard. No federal officer was criminally charged. The family pursued the civil route instead, a wrongful death claim against the government, and reached a settlement, reported at roughly $1 million. The case drew coverage from 60 Minutes and PBS, and the family took it before the Inter-American Commission on Human Rights, arguing the United States had failed to hold anyone accountable. The criminal outcome, though, was a declination. Now consider Claudia Gomez Gonzalez.
In May 2018, Gomez Gonzalez, a 20-year-old indigenous Guatemalan woman from the Maya Mam community, was shot and killed by a Border Patrol agent in Rio Bravo, Texas. CBP's initial public account described a group of people who rushed an agent and referred to blunt objects. That account was revised. A later statement removed the claim about weapons and described the agent firing at a group. A bystander's aftermath video circulated widely. DHSOIG and the FBI reviewed the shooting. Ultimately, federal prosecutors declined to bring charges against the agent, who was not criminally prosecuted. Reporting indicated the agent was cleared of wrongdoing in the internal process, and the family later pursued civil claims. Different state, different agency officer, same statutory framework, and the same endpoint, a federal declination. 2 cases, 8 years apart, both involving unarmed people, both drawing national coverage, both producing homicide findings or serious injury findings, and neither producing a federal criminal charge against the officer involved. That is not a coincidence. It is the willfulness standard doing exactly what Screws designed it to do. So what determines the outcome this time? A few concrete things, and the first is evidence you cannot yet see. The body camera question is central, and here the details matter. Customs and Border Protection, under its national body-worn camera and critical incident policies adopted in 2021, committed to releasing relevant footage of critical incidents, which includes uses of force resulting in death, generally within 30 days, subject to redactions and to exceptions where release could compromise an investigation. ICE's body camera program is newer and far more limited in deployment, and its release framework is less firmly established than CBP's. So whether footage even exists in this case, and when the public sees it, depends heavily on which officers were involved and what they were wearing. The public won't see that footage for weeks at the earliest, and here's why that matters. Until it is released, essentially everything the public knows about the sequence of events is a contested account. The footage, if it exists, is what the review turns on. The second factor is the grand jury and prosecutorial discretion. Even if career prosecutors believe a case is close, they are not required to seek an indictment, and the Justice Department's own guidance directs prosecutors not to bring charges they do not believe they can prove to a unanimous jury beyond a reasonable doubt. That is a high, deliberate bar, and in civil rights cases against officers, the willfulness element makes it higher still. A grand jury can indict, but prosecutors decide whether to present the case at all. The third factor is time. These reviews are slow. Hernandez-Rojas took 5 years. Declinations are not usually announced in weeks. So the absence of charges this summer or this fall would tell us very little. The process is measured in months and years, not news cycles. Which brings us back to the promise, and to that one word, rare. Look across the last 15 years of fatal shootings and in-custody deaths involving CBP and ICE personnel, a period during which advocacy organizations, ProPublica,
and outlets like Reuters and U.S.C. adjacent national security reporters have documented dozens of deadly encounters at and near the border. Compile the cases where a federal officer was actually criminally charged for an on-duty killing, and the list is startlingly short. It can, quite literally, be counted on one hand.
The most prominent exception, the case people point to precisely because it is exceptional, was the prosecution of a Border Patrol agent in the cross-border shooting death of a teenager, Sergio Hernandez, near El Paso and Juarez, a case that itself went all the way to the Supreme Court on the separate question of whether the family could even sue. Charges, where they come at all, are the outlier. Declinations are the rule. The pattern is not really about any single officer's conduct. It is structural. The Screw's willfulness standard was written to protect officials from being criminalized for honest mistakes, and in doing so, it set a bar that separates this use of force was unjustified from this officer committed a federal crime. Those two findings are far apart, and most of these cases live in the gap between them. That is why families so often end up in civil court seeking a settlement, rather than watching a criminal trial. The civil system asks whether the government must pay. The criminal system asks whether an officer acted willfully. Historically, the answer to the second question has almost always been not provably so. So here is the one detail to hold on to. Under CBP's critical incident policy, the clock on releasing footage of a fatal use of force runs about 30 days, which, measured from July 13th, points toward mid-August, on or around August 12th, as the window in which any footage governed by that standard would ordinarily be released or formally withheld. Whether that deadline applies cleanly to an ICE-involved incident is itself one of the open questions this review will settle. Watch that date. Watch whether footage appears, whether it is redacted, and whether the agency invokes an active investigation exception to hold it. Because in a process defined by a single word decided 80 years ago, the first real test of transparency will not be a verdict or an indictment or a press conference. It will be a camera, and whether the public is allowed to see what it recorded.